So I found myself again preparing to visit Ashford. I meant to mention before, the judgment that came down from the appeal court, because it had quite important ramifications, because it's business about getting an uplift for some other substantial reason dismissals. You can actually get it online. If you type in Lund versus St Edmund's School, you'll find it. You can read it all. It's quite dense, but you know, as I said, it was quite scathing of the points that they made, you know, about the original tribunal's findings. Anyway, so I was working on witness statements. And basically I was just pointing out some of the things that had been highlighted in what the judges in London had said, especially the stuff about my pension loss should have been calculated on using the substantial loss method, you know, because of my age and the stage I was in my career, etc. And obviously about the uplift, you know, I said nobody could argue they followed any sort of process, etc., etc. And also that, you know, even in their original judgment at Ashford, they'd said it will be very difficult for Mr. Lund to find another job with equal salary and with final salary pension. I mean, they'd said it themselves. So I thought I was on pretty safe ground there. You know, what could go wrong? Crikey. Now, the other interesting thing is, not long after that judgment was published, Employment Judge Sutton retired. Now, I don't know anything about the details about that, but I thought that was quite significant. I don't know whether he was due to retire, whether it was you know, I don't know, maybe I'm just reading something in it that wasn't there. And so, because it should have been remitted back to the same tribunal who'd made those original findings. But obviously it couldn't be, so this other judge was appointed, Judge Wallace, a lady. I think her name was Victoria Wallace, I don't remember. Anyway, unusually we had a pre-trial conference. It was on the telephone conference. So there was me, the judge, and what was her name? The one from the school's lawyer, Banerjee or something. She came from Cripps and somebody in Tunbridge Wells. Doesn't matter. Anyway, we were talking about how we were going to do things and bundles and dates and when people are available and this sort of stuff. And you know, they said, "Is there anything else?" The judge said, "Is there anything else you'd like to bring up?" And I said, "You know, I wonder whether you'd be prepared to have a look at some of the original findings from the first tribunal, because, you know, particularly about, you know, people not wanting to work me and, you know, my record of poor conduct, etc." And she slapped me down pretty quickly, I have to say. She said, "The only thing we're going to consider is the uplift and the steps you've taken to secure a job, you know, with a final salary pension. That's all we're going to talk about. There are no other considerations going to be made." So, okay, there we go. So that was that. So we duly turned up for the tribunal again in Ashford. So there was this Judge Wallace, flanked by the two original lay judges from the original tribunal, and the school presented their case. Now their bundle was largely it was almost exclusively made up of jobs taken from the internet, you know, that I could have taken, heads, you know, technology teaching jobs and things. And so that's what theirs consisted of. And obviously when my chance came, I'd included an application form in my bundle, and I said, if we just look through that, you know, you can see, for example, near the beginning in my employment history, you can see that I left my teaching job in October, you know, during the academic year, and there couldn't be a worse time to leave than a month into a brand new school year. So obviously that will flag up any potential employers. There was something going on. In fact, as I'm going to do one more of these, probably I'll probably explain. You know, I knew this to be a fact because it had happened a couple of times. When we go a bit further through, I said under my qualifications, you can see that I'm not a graduate. I haven't got a degree. I've just got a certificate in education. And if you look at most of the, well, all of the jobs, in fact, all of the jobs that were in the schools bundle, they said they required an honours graduate or a good honours graduate or something. So that was that. And I said perhaps the most important thing is if you look at the back, the last thing these things always say on application forms is, you know, names of referees, one of whom must be your last employer. And my last employer wouldn't give me a reference. And seeing as I'd been with them for 20 years, and my previous employer to that had gone bust, and my previous employer to that was a school that no longer existed, there was no way I was going to be able to fulfil that. And I said, you've only got to look at the history. When I was unemployed, I was applying for hundreds of jobs, dozens of teaching jobs, hundreds of other jobs without success. You know, end of story. So that was pretty well the end of it, except that bizarrely, I don't know how he came to say it, but Mr. Smith managed to sort of get a final two penny thing. He said, when Mr. Lund used to go into the staff room at school, you know, people used to get up and leave. And I was able to question him on this, and I said, well, that's an interesting observation. When did you start at the school? Oh, I started in September 2010. Well, I was suspended in May or April or May, and sacked in October. So you never actually saw me in the staff room. So at best, you know, that's hearsay, and at worst, it's just a lie. You know, we've already established. You know, I established the previous one. Nobody said they didn't want to work. Anyway, that was a little parting shot he managed to get in, and that was that. I felt reasonably satisfied with what I'd done. Nobody could argue that I hadn't tried very, very hard to get unsuccessfully to get a job with a final salary pension. Bear in mind, this was in 2014. This was 4 years. You know, it's 4 years since I lost my job. This had been going on for a long time. So I was speaking from a position of knowledge, not just speculation. So we just had to wait for the judgment to come through. Big fat envelope arrives, great big wad of folded paper, judgment appears, and started off by saying we agree that the uplift should have been provided. You know, we concur with what the judges in London said. So he will get I think it was a 10% uplift, the maximum allowable. So I got some money from that, but bear in mind, of course, any money I got, because of the original judgment, was reduced by 2/3. I got a few £1,000s from that, which helped pay for what I'd had to shell out on the barrister. And then as I read on, it was one of those sort of ear-ringing moments. You read on and it said something about Mr. Lund would have been sacked in all probability within the following year. So the comments made about calculating his pension from the London Appeal Court don't apply. In fact, it said, in fact, it is 100% certain that Mr. Lund would have been sacked within a year, which was an extraordinary thing to say. So that was that. Okay. I was absolutely gobsmacked. The first thing I did was I got in touch with the appeal tribunal in London, or their office people up there, and I said, I've just had this judgment come through, and they've completely ignored what the appeal court in London said. They've just dismissed it completely out of hand. Don't they check on it? Don't the people in London? And they said no. I said, what? So the appeal court make a judgment and they make recommendations to the tribunal, but they don't check to see that it's been followed through. And they said no. It doesn't happen. I don't know whether they said it doesn't happen, they don't, or it's not. I just don't know. Oh dear. I think that was probably, after 4 years, that was probably the lowest point. I just couldn't believe it. I just couldn't believe what was happening. What is the point of having a law and a process if it's not seen to be done? I thought, well, I applied to the Ashford Employment Tribunal, Judge Wallace, for a review in writing, and I was saying things like, I mean, how can you say it's 100% certain? Are you saying that I would have ignored informal warnings, ignored verbal warnings, ignored written warnings, ignored a final written warning, and got sacked, all within a year, when they hadn't even started a disciplinary process? Because I mean, how can you say that? How could you come? No, I just couldn't. I couldn't believe it. And she wrote back and said, basically, that's our opinion. It's 100% certain you would have been sacked. End of story. So everything they said in London didn't apply to your case. And that was it, really. I did actually appeal that. I did try to appeal that, but because my head was in such a mess after this, and to cut a longish story short, I ended up going to the Employment Appeal Tribunal again in London, and this was quite bizarre because it was a hearing to see whether I had like the previous one I'd had, whether there was any basis for which I could make an appeal. And it was quite bizarre because we were in this massive courtroom, and there was the judge, and there was what do they call them? The court usher, or whatever they're called, court clerk, and me, just the three of us in this courtroom, which was a little bit strange. And basically, the guy looked through it and he said, judges don't second guess other judges, or words to that effect. And he said, I've looked through all the previous stuff. And I mean, fair dues to the bloke. The bloke had done his due diligence, or whatever it's called. He looked through it and he said, I know that what you want from this process, i.e., you're not happy with the original judgment about me contributing to my dismissal by my conduct. He said, I know that's what you want to change. And he said, I have to tell you, Mr. Lund, that will never change. That is done. He said, there's no prospect of you ever getting that changed. So, and the other thing is, I'd gone over time. It's meant to be, you're meant to put appeals in within 40 days, and I'd gone way over time. He said, you've gone way over time. He explained to me why you have to have time limits on these things so things don't drag on, etc., etc. But basically, he said no. So that was in 2015. So 5 years. So I'd been struggling for 5 years. I'd done everything I could. But I lost. They'd beaten me. I was done.